Welcome to the Future of Liberty, a project of Liberty Fund, hosted by Mitch Daniels.
At the Liberty Fund, we're interested in exploring the future of liberty. We hope it's a bright one, but we accept that it's always a question that a free people has to worry about. There are a few people we could invite to explore that subject with us more esteemed than Philip Hamburger, the Friedman Professor of Law at Columbia University. Thank you very much for joining us.
Thank you.
You may be the nation's premier expert on threats or at least the incursions of the administrative state into the freedom of individuals and associations. My first question is to ask you, how do you think we got here? This was not always a problem. Can we blame it all on Woodrow Wilson, or is it more complicated?
That would be fun to blame it all on him, but I don't think even he deserves that. There are layers, aren't there, behind all of this? Most basically, we're human, right? And so the temptation to do things that we shouldn't is always there. And the temptation to power and increasing it just runs through history, and Americans are not so exceptional that we can escape it. So that's part of it. I suppose we could also blame those 19th century Americans who were eager to get out of their provincial status and went off to Germany, especially Prussia, to learn about the latest advances in Prussian political theory, which of course was all about administrative power. But Woodrow Wilson actually didn't go to Germany. He just read German books. And apparently his German was so bad that when he seems original, he was actually just misreading his sources. I suppose the most immediate reason we have an administrative state is actually a matter of class, unfortunately. We don't often think about class as a driving force in American history. But in the 19th century, as today, there are many highly educated Americans who thought that with that academic education came a degree of expertise and a certain authority in governance. And many of them, being progressive, welcomed equal voting rights, but weren't happy with the results. And so in 1870, Black Americans get to vote, at least in theory. 1920, women. And the 1960s, for Black Americans, voting begins to become a reality. And when this happens, of course, many progressives are disappointed with the political outcomes. And Woodrow Wilson complains about this vociferously. In a sense, he's disappointed with the diversity of America, which leads to political results he doesn't like. And so he suggests, and others follow, that everyone gets to vote. It's a republic. We all get to vote. But legislative power needs to be taken out of the legislature and put in the hands of people, well, more like us, he thought. And so there's a really rather disgraceful attempt to undermine voting rights. It's really a dilution of voting rights by removing legislative power into the hands of the administrative state. And this is a matter of class anxiety and power, and a power grab, isn't it?
We certainly see it today, in which some people do feel, I'm sure sincerely, that they are more competent, and therefore they're entitled in some way to dictate results to the rest of the country.
It would be nice if they really were more competent.
Yeah. It would still be a danger to liberty,
Yes.
but it might produce slightly better outcomes than we have.
Right.
Of late, many believe that maybe once it was a willful attempt to wrest authority from the legislature, but legislatures, or at least the national legislature, has been complicit, hasn't it?
That's right.
It has willingly ceded some of its authority to the administrative state. A little
That's
safer
right.
politically to do that, maybe.
Right. It's as if the legislatures have been infantilized by the existence of the administrative state. They can hand over all the difficult decisions, all the negative decisions to the agencies. And so the legislatures, Congress above all, can declare we're in favor of clean air and clean water. And then the decisions that might lose you a few votes, that's made by the agency. And so someone complains, they say, oh, we didn't do that.
I didn't vote for that.
Right.
Yeah.
It's disgraceful, actually.
Yeah.
Now, this leads many people to fear, well, we can't get rid of the administrative state because Congress is incompetent. But of course, nothing stays the same. And I think if we were to diminish the power of the administrative state, Congress would grow into its old role of actually legislating. So I don't think they're naturally incompetent. It's just a matter of convenience.
Well, you've taken action on this front. You've formed an organization, the New Civil Liberties Alliance. I'd like you to tell us about its mission. I'm taken with the term itself. You've appropriated the language civil liberties into this campaign. It could have come. You could have named it other things, but I like the fact. I would like to hear you talk about the reason you chose that.
Well, the New Civil Liberties Alliance really is about civil liberties, and it is very much an alliance. We work with other organizations. It's not just about us. There needs to be a movement. Look, the old civil liberties issues in America used to be about divisions amongst people based, let's say, on race or on sex and other classifications. But the primary threat to civil liberties in America these days is of a different sort. It's the administrative state. The administrative state is not just a separation of powers problem, although it is that, and that's serious enough. It threatens our right to have a jury. It threatens our right to have a grand jury. It threatens the presumption of innocence because many enforcement actions are substitutes for criminal prosecutions. It threatens our voting rights. So we still get to vote formally, but it actually shifts legislative power out of the hands of the people we elect. And so it is a civil liberties issue. So in founding the New Civil Liberties Alliance, the primary goal in having a sort of new civil rights litigation strategy was just to recognize this, to be candid, that this is a civil rights issue, not a separation of powers issue alone. And that gets to a second layer of what we do. I greatly admire Alexander Solzhenitsyn. I give my students his live not by lies. He says, live in truth, and if you can't manage that, at least live not by lies. So our goal when we write briefs is not simply to weave in and out amongst the doctrines, which many people do very artfully, and we have to do that to some degree, and I hope, again, artfully. But nonetheless, the best thing we can do is just to be candid about what the Constitution requires. And I think that's a breath of fresh air for the judges. Now, they don't always want to live up to that, but at least pushes them in the right direction, or perhaps better, draws them in the right direction. It gives them a chance to say what's on their minds because they often recognize the truth. So speaking the truth about this as a civil liberties issue is crucial. And then, of course, another element of our strategy is, in fact, to be strategic. The reason I started the organization initially was because it seemed too much litigation about administrative power was point defense. If coal is attacked, people would say, rally around coal. And so you have litigation that's about coal and the particular agency. This is not only inefficient, it usually leads you to lose and create precedent against oneself, and it's very expensive. So what we have to do is think about taking down types of power that cut across agencies.
Yes. And
that has proved to be all of these elements, the civil rights element, the telling the truth, and the strategy of going after types of power has been very effective in just 5 years. So we're very pleased about that.
Well, congratulations.
Thank you.
And Godspeed.
But I just must say, it's not just me. We have great lawyers. That helps.
Other great lawyers.
Well,
it's so interesting you invoke Solzhenitsyn. Not that long ago, I had the occasion to have a conversation like this with another great Russian dissident, Garry Kasparov, the grand chess master, but also an eloquent spokesman for freedom. He said a very interesting thing that I think bears on this conversation, and that was, he said, what we got wrong in Russia when we thought we had an opening for freedom was, he said, we thought democracy was a result. And he said it's a process, and as soon as you allow the people to begin bending the process to their own ends. He said a tweak here, a tweak there, and that's that. And we've seen a lot of bending of processes and
Right.
and perhaps a legal system which has permitted that when it shouldn't have.
Yeah, I love that quotation. I'm actually going to look it up and use it myself, if you don't mind. That makes a lot of sense. So many people who embrace the administrative state do look to the results. I don't think the results are as pleasant as they think, but still, the argument is we actually need to adjust the cumbersome processes of the Constitution, even if it does deprive you of your voting rights, even if it does get rid of the jury. In any case, they say the jury, that's just an old-fashioned thing, isn't it? The processes matter profoundly. And I think that's an important way of thinking about administrative power. It's really a set of irregular pathways. If you think about what absolute power was in the Middle Ages, for example, they drew a distinction between ordained law, the law that was made in the regular processes, and the irregular pathways for royal power. And the administrative state is just the bureaucratized version of that old absolute power, and it too follows irregular pathways. Instead of going through an act of Congress, where the representation is it takes place, and there is necessity of compromising and working things out. Power is exercised through administrative rules, or worse, even what I call sub-administrative power, subtle threats and cooperation and so forth. And this process is bound to deprive most of us of our input into the law, and that tends to lead to all sorts of dangerous results. By the same token, when there's an enforcement action against you in the SEC, you don't get a judge, you don't get a jury. You don't even have a presumption of innocence. They go after you with these fake judges with mock due process. And this is a disaster for our civil liberties.
Yes, a high-ranking official in the current administration rather blithely was a few years ago reported to be talking about workarounds. Sometimes they just needed to do workarounds. In that case, it had to do with asserting that OSHA could require vaccinations by private companies. A maybe more flagrant example is the student debt forgiveness effort made over and over again, despite at least one legal rebuff that says, no, you don't have that authority, and yet here they come again.
That's right. The entire administrative state can be viewed as a workaround, if you will, an evasion. It's sort of a cascade of power. It begins by evading the constitutional processes, legislative and judicial. It then moves on to evading even the formal administrative mechanisms to less formal administrative mechanisms. And when they're tired even of informal rulemaking, it works with a nudge, a shove, a little bit of a hint of destruction. And its power flows down to the lowest level, almost to the gutter. And it's really quite shocking.
And one worries that we've all become, not all, but too many Americans have become inured to it and aren't realizing constant encroachments on what should be basic freedoms.
This is why, actually, I'm so grateful that you're doing this interview with me, because it seems to me the most basic thing we have to do, although litigation is essential and truth-telling litigation is important, most basically, Americans have to understand what's happening. Confucius talked about the rectification of names, or at least his students did, and attributed it to him. And the names we use really do matter. Administrative law judges, they're not judges. Administrative law, that ain't law. That's just power. We have to be very candid about what's happening here. And if we use the right names, then we will understand the truth and we will reject the current brutish way we're governed. That's right.
Let's try to find some cause for optimism. There have been some cases, and you've been an instigator or participant, I believe, in some of them recently, that do give, I think, some encouragement that the courts are beginning to push back against this sort of glacier of encroachment that's been going on for so long. So I'd like to hear you talk about it. from a legal standpoint.
Right.
So the major questions doctrine, I think I've used the correct term, was used to tell the EPA, no, that's a question for Congress.
Right.
This seems fundamental because we can think of so many other realms in which that same doctrine, it feels, would apply.
That's right. Just at the outset, I should say that I wouldn't be doing this if I didn't think we could win. I like to win. I do not litigate to lose. And so we are determined to push forward. And yes, we've seen astonishing change even in the short time we've been at work at this. So that at NCLA, we are determined to make sure we win. Right, the major questions doctrine, it is a cause for optimism. It does suggest that the court is slowly, in its own way, recognizing their dangers. This is a way, now, it's not a perfect result because, of course, it's splitting the baby down the middle. If they were serious, they would say that Congress cannot divest itself of its legislative power, and the executive cannot exercise a power the Constitution did not grant to it. The Constitution says that the legislative powers here granted shall be vested in a Congress. Well, that's mandatory vesting in Congress. So they might do that, and we hope to get there sooner than later. But in the meantime, the major questions doctrine is a way of saying, well, if this is something that looks really, really big and important, perhaps Congress has to decide this, unless it's clear that it wants to transfer this to an agency. It's only a mild little doctrine, but it has the potential, if the court follows up on it, to have some good effect. Again, I'd rather have them be truthful. I want our judges, as I like academics, to aim for the truth, in which case they would not just use the major questions doctrine.
They would tell Congress, it's not that you must explicitly delegate it. There are certain things you shouldn't, you shall not delegate.
You cannot delegate legislative power, period.
Yeah.
Now, some of the justices, I think, are on board with that. But it will, step by step. It's not going to happen overnight. But it's a very good first step. That's right.
There are cases pending now. The one that people are watching the most closely, I guess, is the Chevron case, the case that would undo the so-called Chevron, I guess, deference doctrine. Yes. Got a prediction? And if so, what would if it's a favorable prediction, how far-reaching would that be? Or not be?
I do not ordinarily predict what the court does, but it does seem as if they are willing at least to pull back on it, and hopefully we'll just get rid of it. The Supreme Court hasn't followed Chevron for about a decade. It's only unsophisticated circuits like the Federal Circuit that follow Chevron. So everyone knows it's the walking dead, and we just need a coroner's certificate. So our case is the relentless case. It's about fishing boats, and that's the one of the two Chevron cases where all the justices can vote, including Justice Jackson, who is conflicted out of the other one. And it's a compelling situation. It's a compelling case. They really ought to get rid of Chevron. And the danger with Chevron is...
Discuss the facts for those who may not have read it.
Fishing boats are required to have monitors on board to monitor that they don't take the wrong sort of fish. But the government doesn't put its own monitors there. It requires the fishing boats to get monitors that they pay for. And all of this is unauthorized by statute. And the government says, well, it's ambiguous and we interpret it to permit this. The danger with Chevron in this case and in all the others is very serious. At one level, the danger is that Chevron essentially allows agencies to make rules even when they're not authorized by Congress, as long as there's some ambiguity or silence. And so Congress actually has to say, don't make a rule rather than authorize a rule. It's a way of expanding the legislative power of the agencies. That's bad enough. What makes it especially bad is something I noticed a number of years ago, is what happens in court when these cases are litigated and the government seeks deference. Chevron deference and all the other deference doctrines are really doctrines which actually ask the judges to bow to the legal position of one of the parties, the most powerful party. So I call it not Chevron deference, but Chevron bias, which is it's a gross violation of the due process of law. And if the judges accepted that argument, they'd have to get rid of all the deference doctrines at once. So I don't think they'll rely on that argument. But that should weigh on them. It is not the business of courts to start with presuppositions in favor of one class of clients and against others. That is absolutely contrary to the due process of law. And they really have to abandon this doctrine for the sake of their own reputation, if nothing else.
So you, without making a prediction, it's possible that that they split the baby here too. What would that look like as opposed to I'll call it all of baby
just
outcome?
just a little bit of due process violations by the Supreme Court, and not right. What I think the best we can hope for here is that they will abandon the Chevron doctrine, but leave in place the other deference doctrines, our Kaiser and Mead Skidmore, named after various other cases. There are various other lesser sorts of deference doctrines, and then we will just have to pursue those in other cases, which is fine. That's the way it should work.
In the lesser doctrines, is there a burden on the government to make some showing that they have the authority, or in what sense are these doctrines lesser?
The Chevron doctrine concerns interpretation of statutes,
Yes.
so that Congress's ambiguity gives power to the agencies. Our Kaiser deference is about ambiguities in the rules of the agencies themselves. Can they make a rule interpreting one of the ambiguities in their own rules? This is bad enough, but it doesn't involve statutes. So there's a little hierarchy of these doctrines.
Are you working on a case to go after those?
We'll go after all of them.
Yeah. One defense the Constitution, or the founders, the drafters, thought they were setting up to protect the liberties was our federal system. And here too we've seen erosion, maybe even more so than we have in the expansion of administrative action versus proper legislative action. But there have been some resurgence, it seems, of assertiveness by states, and by states of both persuasions, actually. What do you see going on here, and is there reason for some encouragement?
Right. Well, first, just to state the problem, we had a federal system, a system in which we govern ourselves in two layers, state and local, and then federal. And these are independent systems of government, so one should not be dictating to the other. Unfortunately, because of the sheer growth of substantive legislative power at the federal level, federal power reaches everything these days, and that undermines the distinction undermines the authority of the states. What's more, the administrative power comes in play here because it's not just acts of Congress, but also administrative rules and even conditions that can defeat state law, allegedly. This is a bizarre outcome, and it's very, very dangerous. All of this deprives us of our agency in the very governments, the more intimate governments, in which we have a chance of some real agency. Is there some hope? A little bit. We have some doctrines of the Supreme Court, like the anti-commandeering doctrine, which allegedly will limit some of the intrusions on the states, although there's not much meat on it yet, and I don't know if there will be. Fortunately, some of the state AG's offices have begun to push back, as they should, and that's heartening. And I think there's a lot of good action there. It's a good place for students to go work, for example. I encourage my students to enjoy that.
States have achieved standing in a couple of cases where it wasn't clear that other plaintiffs might, and I guess there's some reason for hope there. I think it's interesting that the so far, if successful, attempts to block the student loan forgiveness, to use a misnomer, student loan transfer, have originated in the states.
That's right. And another case would be Murphy versus Missouri. The NCLA, under Jeanine Eunice, brought a case, Changizi, in the Sixth Circuit, and the judges were skeptical of standing because they couldn't really quite believe just how serious the danger of censorship was. They should have believed it. And then Louisiana and Missouri brought their own case and brought us in with our individual plaintiffs, and that's now in the Supreme Court.
Explain what's at issue in Murphy versus Missouri.
Well, in Murphy, we are seeking an injunction against federal censorship through the social media platforms. It used to be when the government censored you, they would have to prosecute you in court under the law of seditious libel. In other words, Congress had to pass a law against your speech, the courts had to entertain a government prosecution, and you were there. You could defend yourself before you were punished for it. Nowadays, government can actually suppress your speech, and you might not even know it, because they work with the social media platforms. And sometimes it is overtly coercive. They pressure the platforms. And sometimes it's done in more subtle ways that aren't so coercive, but are nonetheless unlawful. For example, the social media platforms, in order to to get things off their own platforms or control people's speech, have to make sure you're not going to another platform to find the speech. So they have to coordinate. But they can't coordinate because of the antitrust laws. So the federal government comes along and says, we'll coordinate for you. We're going to tell you what should be censored this week, and they all fall in line and do it. And in that way, the government is aiding in a violation of the antitrust laws and violating freedom of speech. So there are a lot of subtle mechanisms that go into this. And it's very dangerous because it used to be when if government did something unlawful, suppressing your speech or otherwise, you could find some refuge in other corners of American society. In the states, or a corporation might support you. The private sector was private. Now that line has been blurred. And so when government either pressures or coordinates with all the leading social media platforms, it creates a sort of wall of power. They can genuinely suppress and alter public opinion, whether to change elections, whether to undermine critiques of government policy coming, from some of the finest scientists in the world.
Yes.
They could just censor. Galileo would have had something to say about this, right?
Yeah.
And the government should not be proud of this, but they are. It's more of those workarounds.
Yeah, some of the speech that was apparently suppressed, I guess there's pretty clear evidence of active, as opposed to wink, wink collusion. In the pandemic, that speech turned out to be accurate.
Right.
Scientific theories turned out to be more accurate than the government's.
Right. Jay Bhattacharya, Martin Kulldorff, and others are our clients. These are highly respected scientists. They have more expertise than the government. And their concerns have turned out to be accurate. Masks may not work as people thought. Right. Vaccines may be much more complicated than people thought. We also have clients in another case, the Dressen case. Clients who were pro-vax took the vaccine. Of course, they didn't know about adverse vaccine events because those have been censored. They were terribly injured by these vaccines, crippled, some of them. And they formed a private Facebook page just as a support group, just to say, my legs don't work. Does anyone else have this? What can I do about this? It's entirely personal, private speech. And this got censored. The government insisted that this be taken down and continues to take down that speech. And this is really quite shocking. It is, I think, verging on the totalitarian.
Yeah.
Because it's not political speech even. It's private speech that didn't fit the narrative, and the government therefore wanted it suppressed.
I mean, it is shocking. I mean, even more broadly, simply the original Barrington Declaration point that protection of the vulnerable was a superior strategy.
Yes.
Been entirely validated, and yet it was denounced, censored. And
It comes back to sort of the natural laws of censorship that I've been interested in for a long time. Sometimes censorship is theological, as in the 16th and 17th centuries. Sometimes it's political, as today. But either way, it'll inevitably come back to censoring science, whether it's Galileo in the past or all the Barrington scientists today. Because so much policy and theology turn on one's understanding of the physical world. And so science has to be distorted. And that, of course, is a disaster at many, many, many levels.
If you succeed in Murphy, as I understand it, it will become legal to impose common carrier obligations on the social media platforms,
Right.
which would cure one problem. Some would say it might give rise to others.
So the one case is the Murthy case, which is attempting to get an injunction against the government for its censorship. There is, at the same time, another case, Net Choice versus Paxton, in the Supreme Court, which I have also been very much involved with. And that involves a Texas common carrier statute. When you use the telephone system, AT&T cannot say, oh, you're engaged in bad think. We're going to take away your telephone services. When you send something through FedEx, oh, you're criticizing the government in your letter to somebody else? Oh, we're going to take away your ability to transport your letter. They can't do this. They're common carriers, right? So the Texas statute, its free speech statute, simply treats the platforms as common carriers. It's the gentlest statute in the world because it doesn't even come with damages. The only implication is if somebody has been censored on the basis of viewpoint, they can bring a suit seeking an injunction or declaratory judgment against the platforms, and then they have to comply. So there are no damages at all. But the platforms complain, oh no, it's our free speech to suppress some sorts of speech, and this is our right because we're like a newspaper. That's a little odd. Benjamin Franklin, at the founding, said that his newspaper is not like a stagecoach. He doesn't have to carry everyone. The people do not have a right to be in his newspaper. That's true. But the platforms are very much like the stagecoaches. They're the transporters of communication. And this is profoundly important because this is the only way to stop the censorship. Government will always be tempted to use these massive platforms to censor people. It's as if you had only 5 printing presses in the country. Well, just a wink and a nudge and you can get them to suppress people. So the only way to stop the censorship actually will not be injunctions. It took 5 years to get the injunction, and the Supreme Court's probably going to trim it down. You can't get damages for past censorship because of qualified immunity. So we've got this terrible problem where Supreme Court doctrine actually bars a remedy for past censorship and impedes an effective remedy for future censorship. So the only thing that will stop it is common carrier rules that limit viewpoint discrimination by the platforms. So we'll see. My hope is that it will get that the Supreme Court will recognize a facial challenge is inappropriate. But who knows?
One can hope. So we've talked a lot here about impositions by the administrative state that amount to coercing individuals, states, companies to do things. You said there are more subtle ways of constantly being devised, and you've been writing about one of them. The title of the work sort of says it all, Purchasing Submission. But I think we could look at this as if the other tactics are blackmail, this is bribery. How's it work?
Well, that's right. We have illusions about how we're governed. We think it's all by Congress makes laws that bind us and then courts adjudicate them. Well, the Congress isn't making those laws on the whole. The administrative state is. But that's not all it does. We've moved from the rule of law made by Congress, the rule of rules made by agencies. And then Congress and the agencies can also just offer a little bit of support. It could be the privilege of a privilege. It could be money. And with that just comes a condition limiting when you get the money. But of course, those conditions can vary. Some of them are perfectly okay. If the government buys an airplane from you and they say, but we're only paying for it if it flies, that's perfectly reasonable. But other conditions are a mode of regulation. They tell you you're going to actually have to submit to a sort of regulation that we couldn't pass ourselves constitutionally or couldn't get by politically, but we can pay you for it. And this devolves lawmaking not merely from Congress to agencies, but to a private transaction. You don't even know who's subject to it because that's all a matter of a little contract, if you will, with the government. And of course, it allows government to buy off political opposition that would have formed in opposition to an administrative rule or legislation. So this is very dangerous stuff. Another problem with the conditions is that many of the conditions are used by the federal government to violate constitutional rights. If government were directly to order universities to set up censorship boards to govern research, everyone would rise up and say, no, you can't do this. So instead, they simply say that funding for research in human subjects is subject to the condition that the university have something called an institutional review board, which in fact reviews your research and its publication prior to publication to eliminate anything that seems insensitive. So there's a profound threat to rights through conditions as well.
I was curious about your view on these this other mechanism in which people sue a government administrative agency who is happy, the old line, to be thrown in the briar patch, and signs a private settlement to do things which, again, may be a very limiting of the rights of others who were no party to that agreement. In this case, no money even had to change hands. They simply signed up for it. Is that is there a way to stop that?
Yeah, it's a very clever way of governing, isn't it? And you get the courts to embody these settlements in their decrees, and so if you violate it, it's actually in contempt of court. This is scandalous way of governing, and it's been done by left and right. No one has any virtue here. The problem is that, one, Congress is the one that should be making our laws, not the judiciary. And two, judges have a duty to exercise merely judgment, independent judgment in accord with the law of the land. The judicial power is placed by the Constitution in the courts. The judges, in contrast to that power, have this very constraining duty. When they approve these settlements and embody them in consent decrees, they are putting into a judgment that which they know is not the law. It can give money to third parties. It can impose duties that are not stated in the law. And however you slice this, the judges are affirming in their judgments what isn't law. And this is shocking. It is outside their power and their duty. And we look forward to litigating that.
Have we seen in other words, a constitutionally minded judge could say, regardless of the merits of this settlement you've brought me, I ought not impose it.
Right.
Have we seen that happen?
That has not happened yet, but maybe with a little nudge we can get them there.
Well, don't stop at a nudge. Give them a good hard shove.
Oh, no, we're always very polite and respectful. We want to persuade. But if you tell the truth to the judges, if one's very candid about how unlawful this is, maybe some of them will recognize it. Yeah. And the danger is that so much litigation bends itself to what they think the judges find acceptable. On the contrary, I think judges have to be told that what they're doing is unacceptable, and then they'll move a little bit in the right direction.
Well, Philip Hamburger, if in fact our freedoms and our respect for process moves in the right direction, you will undoubtedly have been one of the prime movers. We're grateful to you for the work you're doing.
Thank you.
And for taking this time to explain it to me and to our audience.
Thank you. I'm most grateful.
Thank you.
Thank you.
The Future of Liberty has been brought to you by Liberty Fund, a private educational foundation dedicated to encouraging discussions of the ideal of a society of free and responsible individuals.